everyone, welcome to The Brief. I'm Sanam Siddiqui.
I'm Dheeraj Gupta.
Last week at The Brief,
AQIL HUSSAIN, fighting for his sister, filed a writ petition before the Delhi High Court, which was adjudicated upon on the 22nd of June 2020. It was a habeas corpus writ petition for his sister.
Before we get into that, let's discuss what is most important for a habeas corpus writ. A writ of habeas corpus would not lie where a person is under detention or arrest in pursuance of orders passed by any court. A person who is in custody, either in police remand or in judicial remand, cannot maintain a writ of habeas corpus unless judicial authority which has remanded the detenue is a usurper of authority. High Court shall examine whether the detention of the detenue is illegal. On the date of the petition, if no further developments have taken place between the date of institution of the petition and the date of hearing.
The facts of the case were that the sister of the petitioner was wanted in a case FIR number 48 of 2020. The bail application that was filed by the sister of the petitioner was dismissed by the learned Metropolitan Magistrate. However, it was subsequently allowed by the learned Sessions Judge Shadra Court.
The petitioner stated that despite being released on bail, his sister was still illegally detained in FIR number 59 of 2020 by the crime branch. He also pleaded that the functioning of special courts under the National Investigation Agency Act was suspended since 23rd of March 2020. Therefore, the continued detention of his sister is without any authority of law.
What were the issues before the court? Who should represent the respondents? That is the state or the police in this case. Whether the counsels representing the police or government have any authority to represent the respondents under the National Investigation Agency Act. The third issue was whether the learned ASJ, that is the Sessions Judge, had the authority to extend remand since the learned ASJ was not a designated court under the National Investigation Agency Act.
As for who should represent the respondents, the counsel for the government of the NCT of Delhi conceded that only the special counsels, that is, Solicitor General and other senior advocates and advocates appointed as SPP, which is a special public prosecutor under subsection 8 of section 24, can represent respondents.
When the authority to represent under the National Investigation Agency Act, the court said the plea raised by the petitioner was meritless. Honorable Court observed that a court exercising writ jurisdiction is not a special court in terms of Section 11 of the National Investigation Agency Act. Neither has central government directed National Investigation Agency to carry out any investigation.
What about authority to extend the remand? Rejecting all contentions of the petitioner, the Honorable Court took note of the de facto doctrine and held that the learned ASJ was competent to deal with the bail application as well as the aspect of remand of the detenue.
The case discussed quite a few important aspects of the law, the following being procedure for appointment of special public prosecutor under Criminal Procedure Code. The judgment discusses in detail the appointment of public prosecutor under the National Investigation Agency Act. It also discusses the appointment of special courts under the National Investigation Agency Act and the de facto doctrine of authority.
Thank you for staying with us.
Thank you for watching. I hope you had fun.
If you like this episode, please click on the subscribe button below.
And also you can find all the presentations on LinkedIn. And find us on The Brief. Who should represent the ASJ, that is the Distance Sessions
The National Investigation
Agency Act.
under the National Investigation Agency. Wait.